Hello, welcome to Legalese. I'm attorney Christopher Lilly, I'm your host. We're joined today by Judge Margaret R. Guzman, who is now the presiding judge of the Ayer District Court. Welcome, Judge Guzman.
Thank you very much. I appreciate you inviting me.
Well, I appreciate your coming and talking with us. Today, today's title is Topics from the Ayer District Court with Judge Margaret R. Guzman. Judge Guzman has recently been named as the presiding judge in the Ayer District Court as of March, I want to say?
The end of March?
The end of March. She's been terrific there in that role, and she was kind enough to come out and talk to us about some of the topics of the Ayer District Court. Judge Guzman comes from Worcester County. She previously was a trial attorney with the Committee for Public Counsel Services, which dealt with a lot of, or still deals with a lot of indigent clients in criminal defense. She was named as a judge, or sworn in as a judge, in 2009, and primarily had focused in Worcester County as a judge, correct?
I did for the first 6 or 7 years. I spent 1 year helping out with some of the judge shortages in the lower part of the state, down in New Bedford, Fall River. I've also done visiting judging in the western part of the state, out in Pittsfield, Great Barrington, Springfield. So I've had a chance to really, a real joy to travel throughout the state, being a judge in all kinds of different courts.
You had mentioned to me that you truly enjoyed the New Bedford area.
I love New Bedford.
Yeah.
It's Massachusetts has so many industrial cities that lost that manufacturing and industrial base, suffered serious financial consequences as a result of it, from Pittsfield losing GE and Lowell losing the clothing industry, down to in Worcester, the Gardner area losing furniture. So many of our metropolitan areas have suffered financially at the loss of manufacturing. And New Bedford was no different, suffered that, and Fall River suffered really a lot of financial loss. But all of these communities share something really in common, which is a grit and determination. The people who have stayed are really hardy and are, fight for their community, not dissimilar to some parts of Middlesex County. And what's left, however, are a lot of financial hardships for the community. They lose the money coming in from industry, so it's more of the tax burden falls on independent people, homeowners, and you lose a lot of services. Mm-hmm. So the challenge is, what often happens is the courts see when there are these fractures in the communities based on financial hardship, especially over a long period of time. Additionally, what we have seen, really just an exponential increase, is the effects on a community of substance abuse, alcohol abuse, issues related to addictions, things that have gone untreated in a real serious way for a long time. So all of the communities that I talked about, including communities that did not suffer financial loss, communities that were very that maintain their financial base, have all suffered very many similar problems throughout their community. Crime that's associated with it, the dysfunction in the families, and the unbelievable confluence of all of those problems on the courts.
Mm-hmm. So you're seeing a lot of similarities from community to community.
You do.
Throughout the Commonwealth.
Absolutely. And the things that make us different are pale in comparison to the things that make us similar. So.
Mm-hmm, mm-hmm. Now, from 2009 to the beginning of 2017, you primarily were in Worcester County.
I was primarily, and I was mostly by choice. I liked the idea of being one of the team of judges, mm-hmm. rather than being the presiding judge. Mm-hmm. The presiding judge is, I don't know, the boss of the court. It becomes your primary place. Mm-hmm. I liked moving around, and not just around Worcester County, which has a number of courts, but also around the state. But there's a point at which it comes where you want to have a home, and the Ayer District Court opportunity came to me at a perfect time. I was happy to have the opportunity to see if it would be a fit for me and for the court.
So Ayer, I think, is uniquely located. It's the center of Middlesex County, or north central Middlesex County. It is also right on the border with Worcester County. So I think Ayer shares a lot that Worcester County shares. Right over the border from Ayer is Harvard. And that transition from Worcester now to Middlesex, how did you find that transition?
It was really not much of a difference, as you said. I mean, there's a geographical connection. I sat in Fitchburg for many years, and they have a border with New Hampshire. There's often those cross-state issues which come up, which are unusual in some courts. What's really unusual and distinctive and very interesting about Ayer is the number of communities that the court services. It's really unusual for any court to have this many different police departments and towns that it covers, including, so we have in our court 10 separate towns or cities, municipalities, and 3 state police barracks, and a Department of Correction facility, and also there's the potential for some of a sheriff's department to come in. So the number of different law enforcement agencies that interact with our court is extremely unusual. It adds a very unique element because you're not dealing with the personality of a single law enforcement agency, and yet somehow it works. It seems to work very well. I mean, we just had a very big arraignment in our court on Monday, in which the town of Groton suffered a very significant loss of 4 residents, very tragic loss, and there was a very, very high-profile arraignment of a suspect. Both Ayer and the Groton Police Departments combined to provide security for the court. Our court staff, from the clerk staff to the court officers, did an incredible job to maintain order in the court, even though we had numerous news agencies and different forms of media, print media, film, and of course the natural heartache and the heightened concern regarding the allegations themselves. We also on that same day had a shooting incident from Pepperell. So, and the court handled itself with professionalism, security for all of the people who were there. It worked as it was supposed to work, and that is something that is a kudos to the professionalism of all the people that work in the Ayer District Court.
Yeah, they are certainly ready for anything that comes in.
That sleepy little court, really.
Yeah, well, deceptively appearing to be sleepy.
Exactly.
Sleepy. I don't know that it's too sleepy.
Right.
To me, it's always busy, and the security has always been top notch.
It is because passion and crime and dysfunction happens everywhere. It's exponential when you have all of these different towns. But we had discussed what we might talk about today, and I think, I mean, I'm very happy to be there, and I'm happy to talk about being there, but I'd really like to talk a little bit about some of the new legal issues that are arising that seem to be the focus of our justice system.
So we had talked about some of the new cases that are coming out through the Supreme Judicial Court, some of the trends that we're seeing. We had previously had an episode on Legalese talking about restitution and the Commonwealth versus Henry case and how that had focused on one's ability to pay restitution. We're now dealing with a new case that's come out, Commonwealth versus Brayan, which deals with the same type of analysis in looking at one's ability to afford, but applying it to a bail situation. What have you seen coming out of that?
Well, I think this is a recognition of our whole society, but our state in general, looking at all issues of criminal justice. The concern, the overall concern, is that every person that walks into that court whatever court, if it's my court or any other court, is treated fairly. And by that, they are not judged by their financial circumstances, but rather by the crime that they're accused of, their need for counsel, the facts of the case, if they are determined to be guilty or they enter a plea that admits guilt, is the sentence appropriate to the offense. There is a greater recognition that potentially there are dual systems of justice. People who can afford a better attorney, people who can afford a bail, people who are of means often may not face the same kind of charges. That's the thought. And so the people who are poor are serving longer sentences, and the question is, are they serving a longer sentence because they're poor, or is it just coincidental to the offenses that they've been convicted of? There is a real sense that as a society, it is important for us to not just try to be fair, but for the fairness and justice to be apparent to the people who are in the system and the people who are not in the system but are just citizens watching what we do. So it's been a good long look by legislators, politicians, policymakers alike. Our Supreme Judicial Court has addressed some of these issues directly. And that, the Henry case dealt with the issue of a person's ability to pay a restitution and whether or not the fact that they are unable to pay should cause them to go to jail because they are unable to pay. We have the precursor to our justice system was a system that involved putting people in jail when they owed debts. It was called debtor's prison.
Right.
One of the very foundations of our justice system was that that is not right. We made a decision that that was not a principle that we wanted to stand behind. In fact, we abolished the ability of that to happen. So in line with that, the courts have really taken a look and tried to ask themselves whether or not excessive fines and fees on people who can't afford it, high restitution orders that they cannot pay, things of that nature, whether or not it's fair to imprison someone for those issues. And that's right for us to look at those. Our Supreme Judicial Court has made a couple of rulings that have caused the judges in the district and the Superior Court, the trial courts, to look at the principles, think about the way that we deal with each individual person in front of us on an individual basis, and take into account these very important principles. Am I setting a bail that's too high for this person to post, and there's no reason necessarily for the bail to be that high? Those are the things they're asking us to think about.
And how are you seeing now that, I guess, assisting in addressing that concern of a disparity between poorer folks or people of means?
Well, the good thing, what I see, is amongst my colleagues and peers, we're talking about these issues. And sometimes just talking about it, thinking about it through somebody else's eyes can help you take a look at an issue and deal with an issue in a different way that might be better for a better outcome. The issue of bail is basically this. What do we need to encourage a person to come back to court? Generally speaking, there's a presumption that people will come back to court. The court tells them to come back to court. It's an order, and they will come back. It's called a presumption of release. If a person in the past has failed to come back to court for a particular reason, to pay a fine, they missed a court date, it gives us a clue as to whether or not they will come back. So the court may say, I think I need to give this person an incentive to come back, and that incentive could be a bail. And the reason a bail is important is because it's a surety. It says, I promise to come back, and I'm going to put up something of value. It may be the defendant putting it up, it may be a family member or someone else. That surety is to assure the person's presence in court. If the person is a person of little means, then, and they are able to come up with $250, that may be an awful lot, and that may be very little to someone who has more means, who might be able to come up with $10,000. it isn't that a $10,000 bail may not be appropriate for an individual who has no money, but it shouldn't be tied to, we should not be setting bail that we know that person cannot meet merely because we want them. We want people to be able to meet the surety. That's what we want.
So you're saying that you take into consideration the fact that this person only has an economic picture that shows X, Y, Z.
It's
as opposed
it's a factor. It's just a factor.
Just a factor, as opposed to swinging the pendulum one way or the other.
Right.
That, okay, this person of means, now we should be setting something higher, and this person who is poorer, we should be setting something lower. You don't want to have that swinging pendulum. You want to have that conscious, intelligent analysis.
Exactly. I mean, it's like any other term of release. If we release someone, there's been an incident at school, and let's say it's an incident that did not result in their expulsion or even suspension. For me to order that person to remain away from school is not realistic because they're intended to go to school. It's up to the school to make that discipline. But if a person, if I feel that there is a safety issue, then I have a right to do that. I should do it not as a blanket decision. I should do it based on the circumstances of the person, and it's the same issue with bail. Bail should be set on an individual basis, based on the financial concerns, but also based on whether or not this will be enough to get them to come back to court. So it just requires us not to have a set policy for everyone has to be treated individually.
Now, the Brayan decision didn't say you had to set a bail that somebody can make.
No, it said it's a factor. It's just a factor. And it's the
and
same.
It can be, you can set bail on somebody that can't afford that bail.
Absolutely.
What goes into that decision?
The seriousness of the offense, if they have demonstrated a defiance of court orders, if there's a chance that they're going to face a penalty that's really significant, and that's likely to get them to not come back to court, to flee, to disobey the court order of returning to court on that day, those are all considerations. Past record, family ties, likelihood of success on the merits, whether or not they have demonstrated in the past, in more serious cases, a willingness to come to court, that results very, very much in their favor. We should just be doing it on a case-by-case basis. And it's no different with the Henry decision about restitution. It isn't that restitution shouldn't be ordered, but people should not be penalized if they don't have the financial means to pay it. It's only a consideration. It's one of the factors. And the court just wants us to be, the Supreme Judicial Court just wants us as judges to be using all the tools that we have. And those are tools that we should be considering, especially under just a general principle of fundamental fairness. So it hasn't done away with restitution. It hasn't done away with bail. Those are some of the concerns that the community may have. Those are not true.
It's making, I guess, just the other, as you said, another factor to consider amongst that list of factors. Interestingly, dangerousness is not one of those factors, as the Brayan case points out.
Right.
In setting bail, dangerousness is a separate statute that contains different factors for one to consider.
Person may very well be someone who's going to come back to court, certainly come back to court, but they present a danger to the community. And that is a statute that was enacted specifically to consider things other than a person's likelihood of return, those other issues. But it also provides protection for a defendant to not be punished prior to being convicted of a crime. Dangerousness is a separate consideration from guilt.
Right. Okay, I think one of the other topics we were talking about or touching on was the new marijuana laws.
Yes.
And those, we seem to have new marijuana laws every year.
We do, we do.
We've gone from a situation where a conviction for possession of marijuana means 1 year loss of license, to that being taken away, to a decriminalization of marijuana, to a defense where marijuana, if you need it medically, that can be a defense, to now the legalization of marijuana. Right. How are you seeing all of that play out in the district court?
Well, the biggest change was to convert the possession of marijuana, and we're not talking about illegal sales. We're not talking about sales because it's
Which
not.
are still illegal.
They're still illegal. You can't sell it behind a school, and you can't sell it you know, in a house. Marijuana sales will be regulated by the state. But the biggest change occurred when they took possession of marijuana, just having marijuana on your person, as a criminal offense. They took that away and they made it a civil offense. And that had a very significant impact because since it was no longer a criminal offense, it impacted law enforcement in how they assessed the going about of investigating suspected crimes when marijuana was present. So for instance, if they pulled a car over and they smelled recently burnt marijuana, it used to be a justification for a criminal offense, and that might impact their ability to search a car or continue the detention to do an investigation. That started to change because it was no longer criminal to have smoked marijuana. Setting aside the driving while impaired of marijuana, that's a completely separate subject, but the whole presence of marijuana, finding marijuana on a kid who was you know, in his backpack, it wasn't criminal, it was civil. It was a sea change, and that happened many years ago. And it happened long enough ago that it has allowed the court to kind of get used to that whole change of legal thought, legal probable cause investigation. So we're beyond that. It's no longer a shock to the system because it's, even though it has no longer, it now is going to be legal to possess, or it is legal to possess marijuana. It was only a civil offense for a number of years. So the change now is going to be, instead of out of the criminal justice system, it's the focus and the hard work now will be on the legislature and the governor and the executive office to develop laws in the manufacture, in the sales of it. That's going to be their purview.
It's going to be the Cannabis Control Commission. That's going to.
It's a big moniker, but they have a big job, and so it's really taking itself out of the criminal justice system. However, a huge part of this, and the public needs to really be aware of it, is if the marijuana use impairs a person's ability to drive safely any more than a certain amount of alcohol, that's illegal. And the police are arresting for that, as they should. They're investigating it. We're finding more and more tools for how they detect whether or not a person's impaired by the ingestion of a marijuana product or smoking marijuana, as well as other illegal substances and legal substances if they impair the ability. So that area of law remains live. It will always, because it is a public safety issue, people driving while impaired. So now we're going to be working through how police appropriately detect impairment by marijuana.
Well, that's always been a hot topic,
right.
I think.
And so that's working its way through. But it is still, so that, you know, the idea that just because we decriminalized a substance, we didn't mean we're encouraging its use, and that it still has legal impact in other aspects. And, you know, it's only legal if you're a certain age. You can't give marijuana to you know, someone who's underage. I mean, there's all kinds of legal aspects to it.
Are you finding that the police departments are still bringing marijuana cases, or has there been a shift just away from that particular type of charge?
Well, I haven't seen possession of marijuana, which is when the law changed to decriminalize it, there was a certain percentage. It was a gram if you had less than a gram. But you see very few possession of marijuana cases even over that amount. Still, the sales, distribution of marijuana or possession with an intent to distribute, and the impaired use. Those we're still seeing. I don't think it has impacted the police ability to do any investigations. I find that the police departments, if they believe it is possession, they don't charge in any event. They don't have an interest in bringing cases that are going to be dismissed or resolved otherwise. But anything that's close, I mean, it's important for them to bring it to the court and let the justice system sort it out, whether or not the person's not guilty or the charge should be dismissed.
One topic that you've brought to my mind that I don't think we talked about, but I'd like to get your take on it. Cameras in the courtroom. We were talking about this
a
week as
high-profile case?
being a high-profile case, and how are you handling that, or how are you seeing them being handled?
I don't have any problem with cameras, whether it's video, still cameras. We now allow journalists to take pictures and video with their iPhones or other handheld devices, such as tablets or cell phones. I think that the public has a right to see what's happening in a courtroom. I am not a fan of closing courtrooms, and I am not a fan at all. There's often an attempt to have a private conversation at the sidebar with the judge when it's a sensitive topic. I don't like that. I will do it under the unusual case, but I think courtrooms are meant to be open. The public needs to see, they have a right to know. Right now, on that case that we talked about, the arraignment on Monday, there was a request because of the ongoing investigation to impound. We're not releasing the police reports that were provided to the court in support of the criminal complaint. That's unusual. It's impoundment, and it is there is a favoring of openness and access to all public documents, and a police report is a public document. Except for a limited purpose here, I issued the impoundment order for a limited period of time because of the ongoing investigation. That's being challenged by numbers of the media, the Globe, the Lowell Sun. They are challenging that order, and there'll be a hearing in court next Wednesday on the 20th. And that's important. They have a right to present information to me that might convince me to reverse the impoundment order, and we will see. It will be ruled on by the law. The law is going to dictate how I go with this. The law does provide for some impoundment and some closing of courtrooms and some privacy, but it really, really mostly favors openness, because that's how a public believes there's a justice system, then when they can see it. And I believe in that wholeheartedly.
Well, thank you very much.
You're welcome.
We've run to the end of our allotted time, but I want to thank you for coming and joining us and talking openly about what's going on in the Ayer District Court and
my pleasure.
And your career as a judge there.
See that? All right.
Thank
well,
you.
I hope to come back.
I hope to have you back. Thank you.
Thank you.
All right. Good night, everybody.